after a situation such as that. Although the British government made assurances to the Committee Against Torture in Geneva on Wednesday of this week that they had no intention to introduce any form of amnesties in the United Kingdom, certainly for this Parliament. And so we'll see where that goes. But the point is, it's a long game. It takes 30, 40 years to achieve accountability in some situations. Think of other situations dealing with CIA rendition. Again, something that people have been working on for 15 years, people who've been held without trial for 15 years, and it's going to go for another 10 or 15 years, again, in an established democracy. The most extreme example is not in a criminal situation, but one in terms of discrimination. In terms of human rights law, people always quote as the best example of strategic human rights litigation to change something is the attempt to end segregation in American schools in the 1950s. And people quote the famous case that supposedly brought an end to it. But the reality is that schools in America are now more segregated than they were in 1954 when the case was brought to the US Supreme Court. And so these things take a long time to bring about change. In terms of conflicts, we have some of the examples have been given from Argentina, where they were dealing with the situation in the late 1970s, the early 1980s, but they have now convicted 600 people for things that happened during that particular situation. The same happened in Cambodia, where it took 30, 35 years for a court to be established that could deal with what happened during the Khmer Rouge time in the late 1970s. It takes a long time. Some of them are quicker. The war crimes trials in Bosnia-Herzegovina probably took about, well, work out the dates, it's about 10, 15 years for a tribunal to be established in Sarajevo that was able to deal with the crimes directly in the country where they took place, and has now convicted tens of people, if not more than 100 by now. So these mechanisms are possible, they do take time. So what are the legal tools that can be put in action in situations such as this? Well, some of them have already been described, and the human rights response is perhaps the first one that people will look at. UN advocacy is often the best way to begin. We've heard how the situation in Sri Lanka has been dealt with at the Human Rights Council, but then also at the Committee Against Torture, and also at the Human Rights Committee. All of those are methods by which you can get factual findings and produce opinions and expert opinions on what has been going on, and conclusions about how those situations may be described in international law and in international criminal law. Human rights organizations will use researching and producing reports as a way of beginning to get the information out there. And documentation is the main example of collecting evidence when there is not yet a mechanism in place. Some of the long-term examples from Latin America all started as documentation efforts. The classic one is in Brazil, where the Catholic Church was involved in gathering statements of victims of torture, knowing that there was no real possibility that they could be used in a court in the near future, but publishing them in a document, in a report, that made absolutely clear that torture had been taking place in a very systematic way. And the publication of that report changed the narrative and made it clear that there was a real problem. Bringing legal cases, bringing human rights cases is a classic response, and that is essentially holding the state to account for what happened. It's not the same as criminal accountability, of course, but it's a beginning, and it makes clear that the state has responsibility for what took place. It's important that those take place in a strategic way, where you don't just try and win a case and celebrate that, but you try and use the case to then put pressure on the authorities to bring about a broader change. So using your legal case in the context of advocacy before international organizations, using your legal case connected with grassroots activism to bring the impacted community to be part of that process. And when dealing with difficult situations such as this, where you're often dealing with survivors of torture, those legal cases have to be done very carefully, adopting a holistic approach that looks after the survivors as part of that process. We heard about the despair that you sometimes hear from people involved in legal claims that can take years to take place and to get anywhere. And it's very important that the survivors of torture are accompanied through that process, and it's made very clear by the legal advisors that this isn't a quick fix. To do otherwise will unfortunately enhance that despair, but with a holistic approach that makes sure that there's psychosocial support and medical experts are involved as well, human rights litigation on behalf of survivors of torture can be effective. And it's important to think about the different ways that that litigation can have an impact. The old-fashioned method of human rights litigation was mainly focusing on clarifying the law. People aren't so interested in that these days. The law of torture is fairly clear. But there are other ways that we have to be aware of how you can really magnify the impact of the litigation and the cases you're bringing. Quite often, many involved in cases, and REDRESS has brought about 10 cases involving Sri Lanka to the United Nations treaty bodies. Quite often, the individual victims who are the claimants in those cases are really seeking some form of justice. And that can literally be the fact that the United Nations declares that what happened to them was wrong. And it's easy to underestimate how important that can be for many survivors, particularly those who cannot contemplate that such grand people in a international court may be concerned with what happened to them. And that's a very significant process. Another critical impact of those legal cases is truth-telling. And while they aren't necessarily applying a criminal standard of proof, they're applying a fairly firm standard for the lawyers in the room, that they have to essentially be on balance of probabilities, it's most likely that what happened in their findings took place. And that's an important finding of facts, which is then building a record that can be used for some of the other mechanisms that we've heard about as well. And these cases can, on occasion, have a material impact where they bring about provision of psychosocial support or other methods of rehabilitation for those who are involved. And there are other ways it can change attitudes, political attitudes of the international community. It can start to create changing in attitudes in the government's concerned, when people who disagree with the government's position may feel emboldened by the fact that there are findings from the United Nations. And these findings also galvanize the movement and galvanize the communities that are affected. And so there are much broader ways in which they can have impact, all of which are relevant. And then the other method that we've been considering is, of course, criminal accountability. And you've heard some of the examples of the ways that can be done. Commissions of inquiry from the United Nations or other ways which help establish the facts, even if they can't assign criminal responsibility in terms of a criminal conviction. Hybrid tribunals in various forms, those also take time. Most of them are set up 15, 20 years after the offences take place. If you do them too quickly, they often have problems, because if you're particularly trying to set up a hybrid system that is connected with the country concerned, if you set it up too early, then they tend not to function as well as they could do. And so taking a little bit more time to set up a hybrid tribunal that works is advantageous on occasion. They can be very unusual forms. Perhaps the most unusual form is the tribunal set up to try Hissène Habré, again many years after his offences, but a tribunal that succeeded in convicting him, making very significant findings of fact on behalf of the thousands of victims of torture and other human rights violations of that regime. And so the systems are there, they can take time. And universal jurisdiction, as we've heard. Universal jurisdiction can work. A series of NGOs who are involved in universal jurisdiction cases produce a report published by Trial International that deals with the different cases that are taking place each year, and there are many cases around the world that are progressing using universal jurisdiction. But it is difficult, it has to be said. Some countries, such as Germany or France or Sweden, have a system of setting up a structural investigation, where if they see that there has been a particular bad conflict and they have many potential claimants and or accused on their territory, then they can start to do an investigation ahead of time and get to understand the background, get to understand the witnesses, get to understand the experts that are necessary to progress that. Not all countries have it, unfortunately, including the United Kingdom. Estimates from the British government suggest that over the last 10 years, the UK has rejected claims for exceptional relief to remain or from asylum on the basis that people making that application are involved with war crimes or crimes against humanity. And it happens more frequently than you might think. The FOI requests suggest that up to 1,000 people in the last 10 years have been rejected on that basis here in the United Kingdom. That means that there are up to 1,000 people in this country who may have committed war crimes or crimes against humanity. But unfortunately, there have only been 4 prosecutions in the last 20 years. We don't have structural investigations for universal jurisdiction in this country, although we do have the ability to arrest people who have been involved under universal jurisdiction for torture primarily. That's the main offence which you can use under a universal jurisdiction basis in this country. It is possible to do so, but the most likely way to do it is against people who are resident in the United Kingdom. And as I say, there may be up to 1,000 of them here, and so that possibility is not as distant as it might seem. So the conclusions are that to look at these legal tools in the long term of the fight against impunity, and though it may be difficult to hear it, 10 years on is actually only part of the way through that fight. The field of international criminal law has changed a great deal over the last 10 or 20 years, and we're not yet in a position where we can say that everyone who commits an international crime will be prosecuted, but what we can now say is that they might be, and that causes a concern for people in power and makes them think twice perhaps than they did 20 years ago when involved in international crimes. And what we hope is that with strong and determined civil society organisations, such as we've heard about today, that challenge to impunity will progress further, and so that likelihood of prosecutions will increase as time goes forward. Thank you very much.